of a prosecution process. Mr. Speaker, sir, an elementary principle of the prosecution process is that any decision to prosecute a criminal offense must be grounded in due process and the rule of law. The decision to prosecute is motivated, firstly, by assessing whether there is enough evidence to justify prosecuting a person for an offense known to the law, and secondly, whether it is in the public interest to prosecute the person. It is apposite to note that a prosecution for an offense under the Prevention of Corruption Act cannot, under Section 82(1) of that Act, be instituted except by or with the consent of the Director of Public Prosecutions. This is in line with the fundamental tenet of our Constitution, whereby the ultimate prerogative to institute criminal prosecutions in this country rests with the Director of Public Prosecutions. Mr. Speaker, sir, it is therefore not appropriate to attempt to measure the performance of the ICAC over a given period purportedly by the number of convictions it obtained when it does not have the ultimate control over whether a criminal process will invariably result in a conviction. It follows that it is unreasonable to measure the performance of the ICAC based on convictions when a conviction itself is the outcome of a court process initiated by the Director of Public Prosecutions, and any conviction during the reference period of 2019 to 2022 could well have arisen out of a criminal process started before that time. Mr. Speaker, sir, moreover, under Section 20 of the Prevention of Corruption Act, the first 5 functions of the ICAC are as follows, and I quote, A, to educate the public against corruption, B, enlist and foster public support in combating corruption, C, receive and consider any allegation that a corruption offense has been committed, D, detect or investigate any act of corruption, and E, investigate the conduct of any public official which, in its opinion, is connected with or conducive to corruption, unquote. Mr. Speaker, sir, clearly the functions of the ICAC are thus not to secure a conviction at all costs. Mr. Speaker, sir, notwithstanding this, the disaggregated data obtained from the ICAC for the period 2019 to 2022 is as follows. 1, 51 persons were convicted of corruption and money laundering cases. 2, 177 cases.
Speaker, on a point of order, my question relates to corruption, not to money laundering. I would require the Prime Minister to provide the numbers for corruption, quite clearly stated in the question.
Yeah, but Mr. Speaker, sir, I've been provided with these statistics as it is. Well, if I can get these statistics, I will provide them to you.
You continue with this.
So 177 cases are awaiting trial, and 41 cases are awaiting advice from the Office of the Director of Public Prosecutions. I can further inform the House that for the period 2015 to 2023, 5,593 cases were investigated. 4,492 cases were completed. 601 cases, investigations are ongoing. 424 persons were arrested. 614 cases were sent to the Director of Public Prosecutions. 183 cases were lodged. 127 cases were successfully prosecuted, and 155 persons were convicted. I am further informed that attachment orders in the sum of 2,274,125,877 rupees were effected for the same period. Mr. Speaker, sir, as I stated earlier, the ICAC is mandated not only to perform investigative functions, but also to educate the public against corruption, examine the practices and procedures in public bodies to detect corruption-prone areas, advise and assist such bodies in taking anti-corruption measures. And in this context, I am informed that the ICAC has since 2015 to date undertaken numerous initiatives, including the following: conducting focused, sustained, and tailor-made empowerment programs for public officials of all grades, including new recruits, development of anti-corruption tools. The ICAC has developed the following main documents to assist public bodies: guidelines on gifts and gratifications for public officials, resource guide for attorneys, code of conduct for councillors, code of conduct on procurement, best practice guide, management of contract works for public bodies, and guidelines on exercise of discretionary powers, strengthening anti-corruption infrastructure in public bodies by conducting corruption risk assessments exercises in numerous public bodies, and conduct of corruption prevention reviews and issue of corruption prevention guidance to public bodies. Mr. Speaker, sir, in regard to Part B of the question concerning the renewal of the contract of the Director General of the ICAC, I would like to refer the Honourable Leader of the Opposition to my reply to PQ B/998 at our sitting on 9th of November 2021, whereby I informed the House that the contract of employment of the Director General of the ICAC had been renewed on 29th June 2021 for a period of 5 years with effect from 1st July 2021. With regard to the salary and other benefits drawn by the Director General of ICAC, I indicated that the Prevention of Corruption Act already provides for a parliamentary committee to monitor the operations of the ICAC. The Prevention of Corruption Act also provides for members of the opposition to form part of the parliamentary committee, and according to Section 61(2)(c) of the Act, the parliamentary committee may require the Director General of the ICAC or any officer to furnish any accounting or other records relating directly or indirectly to all financial transactions of the Commission, and to answer any question in relation to such financial transactions. Therefore, the members on the other side of the House have the possibility of obtaining information on the operation of the ICAC through the Parliamentary Committee to the extent that is allowed by the law. Thank you.
I will deal directly with the salary of the Director General. Now, we all know, according to law, it is the Prime Minister himself that sets the salary and terms and conditions of the appointment of the Director General and also the board, etc. This is why this question addressed by the Leader of the Opposition to the Prime Minister, because the Parliament Committee will not call the Prime Minister to answer. So it is his duty today to reply to the nation as to the decision he took as to the terms and conditions of the Director General, which is his own decision. And also, Mr. Speaker, I will remind the Prime Minister that when this question was raised at the Parliamentary Committee, the then Director General, and all my colleagues are nodding, refused to answer the question. So, in the Parliamentary Committee, they refused to answer the question, and this is your own decision, and you refuse to give the information. I would like to ask you to confirm whether the salary is not 650,000 rupees per month, 3 times more than the salary of a judge.
Well, Mr. Speaker, sir, I've already replied. The law, POCA, already provides for a parliamentary committee, and the Act itself, in fact, defines the role of the parliamentary committee, the functions, and what the parliamentary committee is allowed to do and what it is not allowed to do. So these matters are best referred to the parliamentary committee. And now let me remind the Honourable Leader of the Opposition that this law dates back also from the time when the Labour PMSD was in government. And we all know what kind of reply we had in this very House. I don't want to remind the Honourable Leader of the Opposition then, when he was in government, what was the reply that was made with regard to questions that were asked by members of the opposition.
The Constitution and the rules of this House, where a minister is answerable to this House for any decision falling under his responsibility, and this under the law falls squarely under the responsibility of the Prime Minister, and he has not denied the figure that I have given. Now, Mr. Speaker, in the Committee of Supply, this is what the Prime Minister promised to the House, and that was in 2021. From a question from Mr. Bhagwan, what about the monthly salary of the Director? And the Prime Minister says, the same Prime Minister, the monthly salary, I shall get the information. I can table this, Mr. Speaker. So from 2021, we are still waiting for the Prime Minister to get the information. Now, Mr. Speaker, coming to the first part of the question, I have the information concerning the number of convictions. I can understand why whoever doesn't want to give this information. Because in the last 4 years, ICAC has only secured, and listen to this, Mr. Speaker, has only secured 13 convictions for corruption. Leave money laundering, that is a relatively easy thing to prove. For corruption, only 13. And out of that, one guy was supposed to have taken 3,000 rupees and a set of screwdrivers. Another person, 500 rupees. Another person, 13,000 rupees.
Put your question.
Be patient. Another person, 6,000 rupees. So what I'm saying is, out of these 13 cases, Mr. Speaker, most of these are for petty corruption and not a single case for major corruption. And this is, I'm asking the Prime Minister whether he's aware of this. Obviously, he's saying he's not aware of this.
Let me come to the first part. It was not a question, it was a statement, but I will reply to your first part of your statement. You say that you're quoting Committee of Supply. Let me refresh your memory, Honourable Leader of the Opposition, to a question put at the sitting of the 11th of December, 2007. Yeah, you were in government, were you not? Yeah. Listen. Wow.
Order.
When I reply, you ow?
Order.
Did I make any noise when you were putting your question? I did not. So don't ow. Okay. Listen. The question was put by then Honorable Boda, who was in the opposition. Whether he will question to the Prime Minister, whether he will, for the benefit of the House, obtain from the Independent Commission Against Corruption information as to the number of cases reported thereto since July 2007 to date. Listen to that, Mr. Speaker, sir. The Honourable Member is asking about the number of cases reported since July 2007 to date. What is the answer? The acting Prime Minister replied, Mr. Speaker, sir, I am informed that Section 81 of the Prevention of Corruption Act imposes restrictions on the disclosure of information by ICAC. Moreover, Section 59 and 61 of the Prevention of Corruption Act subject the ICAC to the supervision of the Parliamentary Committee. It is the Parliamentary Committee which is vested with the power to make reports to the National Assembly on inter alia, the manner in which the Independent Commission Against Corruption is discharging its functions and exercising its powers. The information requested by the honourable member will surely be made available in the annual report of the Independent Commission Against Corruption. Mr. Honorable Boda was not satisfied. He asked a supplementary question, whether the Prime Minister does not consider that the nation at large should know at least the number of cases which are being inquired by ICAC. The Prime Minister replied, Mr. Speaker, sir, superficially, I would say that the request seems to be reasonable, but on seeking advice, I have been told that if I answer this question, this first question, it will open the door to other questions. This is, no, I'm not finished. I have to reply. Well, you ask a question. What? You want to control my reply now? Now, let me, because your memory is very short-lived, Honorable Leader of the Opposition. Mr. Speaker, sir, on the 8th of November 2011, Honorable Jugnauth then asked a question to the Prime Minister, whether in regard to the inquiries carried out by I have to reply. Honorable Leader of the Opposition made certain allegations towards me about I'm not wanting to reply. Let me remind him what he was in government, what the Labour PMSD government, what kind of reply they were making to this House. Whether in regard to the inquiries carried out by the ICAC, since it's a...
I've never asked any question with regard to inquiries, merely convictions. And the Prime Minister has provided the figure for corruption, but mixed it up with money laundering. I have never asked any question on inquiries. You are beside the point. Convictions.
But if you listen to what I'm saying, you will see I am relevant. I am going to, but you don't want to listen.
Be patient, Honorable Leader.
I don't know if you have read this. You have.
Be patient.
So whether in regard to the inquiries carried out by ICAC, since its setting up to date, he will, for the benefit of the House, obtain from the Commission information as to the number of cases wherein. Okay, I will skip the first part, part A, which is not relevant. But second part B, conviction has been secured. Conviction. You can hear that word, conviction. Okay. What is the reply? I shall reply to PQ and so on. As the House is aware, pursuant to Section 36 of the Prevention of Corruption Act 2002, as subsequently amended, the annual reports on the activities of the ICAC are laid down before the National Assembly. The information requested in the parliamentary questions is already available in these annual reports. Now let me come to the second part of your question. Let me check. You have been saying that I am trying to mix cases of money laundering with corruption cases. Right. Yes, one thing that I agree with you. Section 5 of the Financial Intelligence and Anti-Money Laundering Act states the offense of limitation of payment in cash, which I just quoted so that members will understand. Notwithstanding this and that, any person who makes or accepts any payment in cash in excess of 500,000 rupees or an equivalent amount in foreign currency or such amount as may be prescribed shall commit an offense. And the leader of the opposition has just said that this is an offense where probably it does not take too much of resources and time to investigate before eventually, if the suspect is liable, he will be convicted. So let me give some figures. For the period 2006 to 2014, we are talking about a period of 9 years. There have been a number of persons convicted, 154. 154 convicted, out of which 60 convicted under Section 5 of FIAMLA. As compared to from 2015 to 2023, 155 convicted, out of which 22 under FIAMLA. So if you want to compare, you can see for the 9 years, if you take 154 minus 60 and 155 minus 22 for the 6.5 years. So I think that is also very telling of what the Honorable Leader of the Opposition is saying.
My question relates to one Mr. NB who took over on the 1st of July 2016. Don't try and mix it with 2006 and all that. And that is the first thing. The second thing, if you look at the website of the ICAC, and I remind the Prime Minister, the ICAC is Independent Commission Against Corruption. And that is the main role of ICAC. You will see that there are only 13 cases, amongst which the cases for 500 rupees. And that is why, Mr. Speaker, I'm going to ask the Prime Minister, has he taken note of the dégringolade of Mauritius in all the international indices? Transparency International, we have lost 15 places since 2012. He just talked about the previous government. And previous government, we were ranked 43 in terms of a better rank. Now 15. Mr. Mohib Aimin next, Mr. Speaker. And this is what Mohib Aimin said about Mauritius in the 2022 report. Mauritius obtains its lowest ever score since 2012, when the index started. These, Mr. Speaker, indicate clearly, with the conviction rates that I've given, that there's a major problem at ICAC. And I will come, Mr. Speaker, to my question, whether it is not time now, given this dismal track record, which we all agree, dismal track record, it is not time to scrap ICAC, whether the Prime Minister not agree to scrap ICAC, dissolve ICAC in favor of a totally new organization.
Well, Mr. Speaker, sir, I fail to understand the reasoning of the Honorable Leader of the Opposition. He is quoting from certain reports, which I must check, by the way. But I am quoting figures which he himself has asked me to provide to this House. And when I'm providing figures, now he's saying, well, for the past, we should not. Let me repeat again. For the period 2006 to 2014, 84 persons have been convicted for corruption. For the period 2015-2023, 133. And again, we are not comparing with the same period, length of period, 9 years as compared to 6.5 years. But again, let me say, if we look only at figures, it does not really necessarily give a true picture of the situation. Because, you know, investigating into suspicion of corruption is a lengthy process. We have seen in so many cases where you need to ascertain witnesses' identity, you need to try to get statements from all parties who are involved and concerned. You need to get judges' order. You need to, in many cases, in fact, you need to start MLAs, because you need to get information and evidence from abroad. And that also takes time. So I don't want to restrict a debate only on a figure for one period as compared to the other, although the leader of the opposition seems to be restricting it in that way. There are many, many other factors that have to be taken into consideration before we can ascertain the efficiency of one organization or the other. And I have said also in my reply that not everything depends on ICAC. ICAC, after an investigation, at the closure of a case, will send the file to the Office of the Director of Public Prosecutions. And there, that will be considered, whether there is need for further inquiry, for further evidence to be gathered, or whether it is enough in order to be able to proceed with the prosecution against anybody. And then the matter is referred before a court of law. Now, don't we know that before a court of law, it does take time also? And, you know, cases at times, in fact, I don't want to, because counsels appear also, then cases are postponed for one reason or the other. So we must take all this into consideration. Now, to the last part of the question of the leader of the opposition, I think I have said in this House and elsewhere also that there is in preparation a bill, the Financial Crime Commission bill, that eventually is being worked. I know it is being worked right now by the Attorney General's office. Of course, I am also involved with other members of government. And eventually, when the bill is ready, it will be tabled before the House.
Just one last thing about Kyrgyz. 2016, there were 35 cases of conviction. But since that time, and up to now, last 4 years, I have given the figures. 2022, 3 cases. 2021, 4 cases. 2020, 2 cases. Dismal figures, Mr. Speaker. And, of course, no major case. And there's a feeling, Mr. Speaker, and I'll put it to the Prime Minister, that ICAC, a strong feeling in the population, Mr. Speaker, that at ICAC it's deux poids, deux mesures. The opposition members, of course, there is full force of the law, and so friends of government, it is absolutely the contrary.
No,
and that is the feeling
stop you there, leader
of
the
opposition. Yes?
Leader of the opposition, I'm on my feet. Don't make any insinuation. This is an independent body, whether you like it or not. It has been created by law. You are in parliament. You are leader of the opposition. You have to respect institutions.
Speaker, that the indices that we have, the surveys all show that the population has absolutely no trust in ICAC, and the feeling is that it has deux poids, deux mesures. So I'll ask the Prime Minister whether the solution is...
Leader of the opposition, I am on my feet. You don't have the right to say these things. Deux poids, deux mesures, you don't have the right to say these things.
Like this, because the law gives power to government via the Prime Minister himself, not only to appoint the Director General, to set his salary, to appoint the Board of Directors and set the terms and also to be involved, Mr. Speaker, in the appointment of the various section heads. So isn't the answer, Mr. Speaker, is not only to get rid of Mr. NB because it's totally ineffectual, but also that the law should be changed, a new law coming into effect, which gives no power at all to any politician, and this power be given to the Judicial and Legal Service Commission, as with the appointment of the Electoral Commissioner. Is that question okay, Mr. Speaker, for you? Good.
Mr. Speaker, sir, well, it is not true to say that il y a deux poids et deux mesures.
You're quite intelligent to know what can be said in the House, what can't be said. Intelligence is not the monopoly of the chair. Honorable Prime Minister, please.
Yes. Yes, Mr. No,
Maybe at you.
looking at you.
At you. Maybe at you. Maybe you're failing somewhere in your duty as leader of opposition. Maybe. Take care of that. Prime Minister.
First of all, well, it is not correct to say that there is deux poids, deux mesures. And so let me rapidly come to the question that has been asked. Again, Mr. Speaker, sir, je n'arrive pas à comprendre le raisonnement de l'honorable membre. Hein? Il vient dire, non, mais vous venez dire que c'est moi, I appoint the director. But if we go back to history, what has happened? When the Prevention of Corruption Act was legislated in 2002, right? It provided for the Independent Commission Against Corruption with an appointments committee. The appointments committee, for the purpose of this act, shall be composed of the President of the Republic, the Prime Minister, and the leader of the opposition. And in the exercise of its functions, the appointments committee may also call, I don't want to go through that. I'm sure the leader of the opposition is very well aware of this in 2002. Then what happened? Then, 2005, Labour PMSD came to power. What they did, the first thing, 2005 itself, they amended the Prevention of Corruption Act. Amended the Prevention of Corruption Act to Section 19, the establishment of the commission shall be there, so on and so forth. The director, subsection 4, the Director General shall be appointed by the Prime Minister after consultation with the leader of the opposition and shall be a person of Sasa. So look, this is what you did. And now you're telling me, why is it that I do appoint the Director General? This is provided by the law, and the law has remained as it is. Yes, it has not been amended in that respect. Now, if you want to make a proposal, you made a proposal that we should amend this. We'll see. Well, yeah.
Is that it is the Judicial and Legal Service Commission that takes over all of your functions concerning ICAC or whatever new organization there will be. And secondly, Mr. Speaker, that ICAC no longer bothers itself with petty criminal offenses of 500 rupees, a set of screwdrivers, etc. ICAC has cost its nation 3 billion rupees since its creation and 1.1 billion rupees since the last 5 years. It's not its role to worry about 500. I've started the question. You know, like Mastermind, you start and you finish the question?
Time is already over. Please, I'm giving you the chance of putting your question, and so far you haven't put any question.
Be patient.
This is my point.
Be patient.
Put the question now.
Be patient. So, whether in the law that is coming, to scrap ICAC, I hope, we will put petty corruption back to the CID, 500 rupees, 1,000 rupees, even up to 500,000 rupees, and leave the new organization to deal with real, harmful, nationally important corruption cases.
Monsieur le Président, l'honorable leader de l'opposition, de 2005 à 2014, n'a pas pensé qu'il fallait faire une proposition pour amender la loi concernant la nomination du directeur général. Pendant tout ce temps, c'était correct, c'était bien, la loi comme c'était, qu'ils ont amendé eux-mêmes, d'une manière, je dirais, très transparente, ayant un comité avec le président, le leader de l'opposition et le Premier ministre, pour que ce soit le Premier ministre qui nomme le directeur général. Donc pendant tout ce temps, c'était correct, c'était bien. Et en plus, pendant tout ce temps, alors que, à l'époque, eux, lorsqu'il y avait des questions au Parlement, voilà les réponses que j'ai citées pour que tout le monde puisse comprendre exactement quel genre de réponse on avait. Moi, j'ai quand même donner certaines informations concernant les chiffres. Mais, Monsieur le Président, on peut vraiment comparer la manière de faire de ce gouvernement et la manière de faire de l'ancien gouvernement à l'époque. Alors, le Financial Crime Commission, je peux dire que le projet de loi est en préparation et l'objectif, c'est, as a body corporate, the Financial Crime Commission shall be the agency responsible to combat financial crime in Mauritius and abroad. And the bill will replace the Prevention of Corruption Act and will bring under one structure the different agencies involved in the fight against financial crime, including corruption offenses and money laundering offenses, to ensure more effectiveness in the system and better coordination in the fight against financial crime.
Time over.